First, let me thank the One Text Initiative for inviting me to deliver this keynote. I'm deeply honored. Particularly so because this, as we were all told, is the initiation of a process of public consultations regarding constitutional reform. I'll be very brief in my comments. I will not be offering any specific recommendations because that's not for me to offer, but just to flag certain broad issues. And a lot of what I wanted to say, I think, has already been said. So let me just deal with some fundamentals which I think are very important in my opinion. Yes, it's a very special moment in the recent political history of the country, contemporary political history of the country, to attempt constitutional reform. I say that even though we are all jaded by this idea of constitutional reform. As I was mentioning to an audience the other day, when I was a very young law student, several decades ago, we were discussing constitutional reform. Now I'm a retired academic, and we are still discussing constitutional reform. And in between most of the reform processes, we are not really satisfied with, even the minor ones. So where would this take us? So we have to make sure that we think about the mistakes made in the past. So the positives, of course, as was already pointed out, is that this is the attempt at constitutional reform after the, I think, almost epoch-making Aragalia in 2022, where the people of this country demanded accountable governance and a system change. What is system change is not precisely clear, but it is very clear that especially the youth of this country, they're not happy about the way the country is governed. They're not happy with the political establishment. So it's just not really about changing rules, but it is also about the method of governance. And then, of course, the newly elected government in 2024 has now pledged in its manifesto to introduce a new constitution, and they have highlighted their own priorities for that process. So at the beginning, I must say, just as the previous speaker pointed out, when I received this invitation and I was asked to speak a few words about constitutional reform, strangely my heart sank, even though I'm positive about this. It's again because of this sense that is it going to be more of the same as before? Promises made, a lot of, ideas circulating and so on, a lot of rhetoric, but nothing very much, I think, has been achieved. So in a recent article of mine on constitutional reform, I made this following observation. It captures what I want to say, and I quote, "Sri Lankans appear to be obsessed with constitutional reform." I think it's a national obsession, to be honest, because we think all our ills can be changed through constitutional reform, which is hardly the case. It's just the beginning of change. Constitutional reform is just the beginning. The discourse has largely ignored the fact that countries with deeply entrenched democratic systems of governance have banked more heavily on constitutional conventions and traditions and the fostering of an overall democratic socio-political ethos to sustain their system. So we find that even when there are good provisions which we have achieved through constitutional reform, practice can be at variance with those idealistic provisions. So what we've seen, I think, to be honest, there are many honorable members of parliament, public representatives, civil society advocates. I think we have to recognize the fact that many efforts in the past have really, we have to ask the question whether they are in the public interest. Why is that? Because we see this instrumentalizing of constitutional reform to a great extent. If you look at most of the 21 amendments to the 1978 Constitution, the bulk of the amendments are not in the public interest. Anybody will say that. I mean, students of constitutional law in this first or second year, they go through the amendments and they will say, why were these adopted? So except for a few which are in the public interest, there's a sense that this process of constitutional reform really is about instrumentalizing, and it's for power projects, power political projects. So we, of course, always, even now, as we start this process, One Text Initiative starts this process, we anticipate the process to be idealistic, and that we will be dealing with all the high moral principles that should be in a constitution. But will that be the case? Now, this deep cynicism of mine, I apologize for that, but I'm afraid I cannot say anything else, because I think this has been our experience. Now, a recent report in 2025, the Constitution Net report. The Constitution Net is a publication that comes out of the International IDEA, International Institute for Democracy and Election Assistance, which is an intergovernmental organization. It says the following. And I quote, in 2025, Constitution Net published 30 plus expert analysis and tracked 250 plus constitutional reform updates across the globe. Constitutional reform was everywhere, but democratic progress was rare. So this, I think, is the reality in many, many parts of the world. So when we reflect on our own experiences, we've got to, I think, sincerely and genuinely ask ourselves, have the previous efforts been, genuine efforts at constitutional reform? What really has come out of that? And I point to this, even though one may say it's a very negative note to start with. I say this because I think we have to be very conscious of these developments in the past in order to avoid them, avoid the negative practices. That's absolutely important. So, of course, in order to engage in meaningful constitutional reform, and what we haven't had in the past, I think most of the problematic provisions or problematic constitutional, the framework we see, ironically, was introduced in the Republican era. I mean, if one were to ask us, which is the constitution in the in the independence era that really suits democratic goals, I think a student of constitutional law would say, well, it's certainly the Salisbury Constitution. So this is an irony, because it's a constitution that was introduced by the colonial authorities. Of course, there were contributions by the Board of Ministers in the Ceylonese counterpart, but yet it's still seen as a sort of an outside document that was imposed on Sri Lanka. So if you look at the two Republican constitutions and also most of the amendments to the 78 Constitution, they were adopted with very minimal public consultations. So public consultations obviously is very key in the current process. The government has said, the Prime Minister made a statement in Parliament that the government will be introducing its own draft to the public for consideration. But will that be achieved through a consultation? So that is a major concern. Now, how would public consultations be conducted? That's something we have to ask ourselves. So One Text Initiative is initiating a civil society initiative, which is very important. There was then, in the 2016 constitutional reform process, the Public Consultations Committee headed by Mr. Lal Vijayanayaka, which I think did a very good job. I'm not quite sure to what extent it was used, but I do understand that it was used in that process, and parts of it are reflected in the reports that came out of the 2016 constitutional reform process. But I think a much more meaningful public consultation process comes when people are given the power to decide what they want. It's not something that is initiated by the political establishment, but something that is initiated by the people. I've written about this, I've spoken about this at various fora, but I think there's incredulity when I say this as to whether it is possible in Sri Lanka. I mean, countries which have come up with rather popular constitutions have elected constitutional assemblies which consist of people's representatives from various walks of life. And then they be teachers, maybe academics, maybe from all walks of life, maybe trade unionists, farmers, etc. They come up with a text then, of course, then experts work on it, and then eventually it is submitted to the political authority for adoption, as what happened in South Africa. We saw that process in Nepal too. Now that Nepal has also is experiencing political difficulty, one can question, well, then what happened? But I think we have to look at these processes extremely carefully. What would people expect of this process? It's not just about what the Colombo, the sort of crowd would think is appropriate, but what would people expect from such a process? The point is, the constitution of a country as a basic law is just not, as was pointed out earlier, a rule book. So quite often in the process, if it is a process where the politicians are almost exclusively involved, it often becomes just about the rules, and then there are negotiations about the rules, and we know there's a great degree of political horse trading. So what comes out of it at the end, whether it would satisfy public demands, is really an issue. So I think we have to think of a way in which these public consultations can be done in a very legitimate manner that is acceptable to the people. So in terms of a constitution that will last for a long time, even though the 1978 constitution has lasted for now over 4 decades, yet we are very deeply unhappy with it. But if a constitution is to last with people's approval, I think it has to be something, it has to have provisions, it has to have a dimension that has a resonance with the public, in the sense people develop an emotional attachment with the Constitution. Today the Constitution, both Republican constitutions, are rather alien to the people. Now there's a bit of interest after the uprising and so on, but they're seen as distant sort of documents that have no direct relationship to people's lives. And when you look at some of the more successful constitutions, in our neighborhood, if you look at the Indian Constitution, there's a great degree of emotional attachment to that constitution. And I think that's very, very important. I remember during this, when people took to the streets during this Nirbhaya, the people protesting against violence against women, I remember people carrying placards saying, "Let the Constitution speak for the women of India too." So there's a sense that whatever the issues that Indian society may be facing, the Constitution should eventually work for the people, and it will. So there's a greater degree of acceptance of the Constitution. And I would think even the oldest written Constitution, the US Constitution, adopted at a critical moment, a very important moment of its history, like in India's with the independence movement, somehow there is that attachment. Although now it's in crisis, I think eventually it's the Constitution that will save the day. So the point is, the Constitution itself must not be the problem, as has been the case in our Republican era. So basically, I think our discussions, before getting into specifics like, the executive powers, whether it should be a presidency, etc., we have to think about and we have to decide on what are the fundamental principles that should govern our constitutional order. What are the fundamental principles? That's absolutely essential. And you find in a lot of modern constitutions, there's a provision at the very beginning which spells out the key principles, fundamental principles that will govern the Constitution. So I will very humbly share with you, in 2020 December, our Department of Law at the University of Peradeniya submitted its constitutional reform proposals to the committee appointed by the President Gotabaya Rajapaksa government, which was headed by President's Counsel Ramesh De Silva. And the report is available online, our proposals, and there the first thing we pointed out was that the fundamental principles that should govern the Constitution should be as follows. Of course, it's the thinking of a group of academics. So eventually, I think when we are thinking of a new Constitution, there should be national consensus on what should be these fundamental principles. So the first we pointed out is sovereignty, of course, that the government is based on the will of the people. Basically, it's about a democratic system. And that the Constitution must be supreme. That's absolutely important to enshrine the idea of rule of law in the country, because the current Constitution, there is no supremacy. There can be many laws that defeat constitutional provisions. We know that. Even the fundamental rights chapter, most of the rights can be amended by 2/3 majority, except for the entrenched clauses which require a referendum. So the supremacy of the Constitution, we said, should be a fundamental principle. And then power sharing at the national, provincial, and local levels of government must be established, and I will get to that in a while, and that all levels of government must adhere to fundamental constitutional principles. And then accountability of government to the people. That means it's very important to institutionalize a system of government where separation of powers and checks and balances are enshrined. And then protection of fundamental rights on the basis of equal dignity of all the people, and religious freedom to all, and then environmental protection, including all species for present and future generations. And the provisions are to be entrenched, and the interpretation of the Constitution should be based on those principles. So that was a modest effort by a group of academics to present our thoughts and ideas at that point as to what should be the fundamental principles of the Constitution. Of course, if we were to work on it today, I'm sure there can be, amendments to that, additions to that, etc. But the point is, I think it's very important for this process that is been initiated by the One Text Society to focus on that before getting into the specific substantive issues. So as to constitutional reform issues, I think most have been discussed ad nauseum over the years. There are so many drafts, so many reports. I'm not quite sure whether a lot more work really needs to be done. We have the 2000 constitutional draft, which in my opinion, I think we missed a golden opportunity when it couldn't be adopted. It's true that there are issues about the power sharing arrangements in the 2000 draft constitution, because some say that the 1995 proposals were not included in that, but I think overall it was a very well drafted constitution. Now, where the issues are concerned, I just want to flag a few which are of importance. Of course, the nature of the state, and I think that's where these principles are important. Because the principles should delineate what sort of a state it is. And then, of course, I think the principles should also point to the type of a society that we want to be. The sort of pluralistic dimensions of society should be protected. Whether social justice is a principle that should, would be sort of a all-permeating principle, etc. So the nature of the state, unfortunately, when we today discuss the nature of the state, it is about whether the state is going to be united or unitary and all that. So that's important, undoubtedly, to make sure that all communities can have a sense of belonging, can have ownership of a constitution. But I think it has to really go beyond that. And to me, I think the moral dimension of a constitution comes forth with the fundamental rights protection provisions. That's absolutely essential. We have had two bills of rights. The first constitution didn't have a bill of rights. But strangely, human rights are protected better under that constitution than afterwards. because we had a Bill of Rights in the 72 Constitution with no constitutional remedy. Then we had in the 78 Constitution a Bill of Rights with a constitutional remedy. But if you track the practical dimensions of human rights protection in the country, you see the reverse being achieved. That is, as provisions became stronger, fundamental rights provisions became stronger, the actual practical enjoyment of rights suffered greatly. So it was during, I think, the 78 Constitution that you saw major human rights crisis in the country emanating from the civil war, and various other contexts, the insurrections in the South, and so on and so forth. So I think the fundamental rights chapter has to eventually be a meaningful one where all organs of government take it very seriously. The main thing I think we need to point to is that it should be an all-encompassing Bill of Rights. There were issues in the 2016 constitutional reform process as to whether economic and social rights should be included in that the Bill of Rights. I think now the discourse has gone beyond that. So definitely civil, political, cultural, economic, social, all the rights must be in there, because in a practical sense, Sri Lanka does respect economic and social rights. If you look at education, for example, or healthcare, even though we don't have written provisions in the Constitution for access to healthcare or education, they are respected through public education and public healthcare. So that is absolutely a must. And then the rights must be guaranteed broadly, and the limitations must be articulated in a very narrow way. A fundamental rights chapter, in order to make all communities feel a sense of belonging, must guarantee group rights as well as individual rights. There must be a very powerful equality clause that gives the sense that there is equal citizenship. At the same time, the diversity in society will be respected and protected. There must be an open-ended non-discrimination clause, because we see, for example, today, many marginalized groups not being represented in the non-discrimination clause of the 78 Constitution. So an example would be persons with disabilities. So, marginalized groups we keep recognizing more and more marginalized groups, so an open-ended clause is important. So paying a lot of attention to the equality clause is absolutely important. And then, of course, liberalizing access to the constitutional remedy. There must be an effective remedy whereby people don't have to come to the Supreme Court from all over the country for remedies, that it should be, again, devolved. Maybe regional courts of appeal should have the power to hear fundamental rights cases in the first instance. And then, of course, the power sharing arrangements are very, very important. When at the Peradeniya Department of Law we discussed this issue of power sharing, actually, our position was that power sharing should be discussed not only in the context of how minority rights can be better protected, but from the perspective of deepening democracy. Because this is about providing all groups of people the right to engage in governance at a local level. So in Sri Lanka, it's very difficult to discuss power sharing because of this, perception, and people get overly excited and it becomes very dramatic, these discussions, and unnecessarily so, because this is about deepening democracy. I think all segments of society have to feel that they can participate in governance at the local level, at the provincial level, and so on. So I'm not going to get into details like the role of the governor, etc. I'm sure the panel members will deal with that. And the executive powers, which seems to be at the center of controversy about the Constitution, the executive presidency certainly needs to go. I think in the current government manifesto, also the NPP manifesto, it has very categorically stated that they plan to abolish the executive presidency. It's just that it's interesting. I think this is where we need to, sort of discuss political anthropology. Now, there are those who say, executive presidency in a sort of a limited way might be better for the country, etc. But I'm just wondering whether there can be a limited presidency in that sense. Because there's something about the character of our, the political character of our society that seems to constantly want to concentrate power, whatever the provisions that may be. We saw that under the 19th Amendment as well. The sense that the 19th Amendment weakened the presidency so that the president couldn't act in a decisive manner. So I think, I don't know, it will be through consultations, we'll find out whether there's consensus about the abolition of the executive presidency. And then, of course, if that is the case, we have to discuss what is it that we are going to replace the executive presidency with. A parliamentary system, of course, but how do you ensure that the executive prime minister also does not become a sort of a monolith and then concentrates power and then becomes a problem to the people. And then the all-important issue of checks and balances. None of these provisions are going to bear fruit, including definitely the fundamental rights chapter, if the constitutional order, if the constitution does not have a strong system of checks and balances. And this is about, of course, we say judicial review of legislation is absolutely a must. There seems to be consensus on that. You really cannot have a democracy without judicial review of legislation. That's a fact. But depoliticization of institutions is of the essence. This seems to be so hard to achieve, even sometimes at a time when the Constitutional Council is functioning. So we have to focus very much on the independence of the judiciary. It's so important to the people, and other independent institutions such as independent commissions, various officers like that of the Attorney General, Auditor General, and now there's a proposal for a Director of Public Prosecution, which I personally think is a good idea. So all those positions, how do we really make them independent? So again, there is that dilemma. We have found a way. We think that a strong Constitutional Council getting involved by recommending names or by approving names might make a big difference, but we cannot be sure all the time. We cannot be sure all the time. So whether, of course, the Constitutional Council is important, but whether we should go back to the 17th Amendment model of having more distinguished citizens forming a majority than the current situation where there are only 3 distinguished citizens on it, and they are clearly a minority. Whether the Constitutional Council, can function effectively this way, or whether its composition has to be changed. The point is, it's of the essence. I cannot emphasize it more. Whatever the provisions in the Constitution are, even if the executive presidency is abolished, unless we get this system of checks and balances put into the Constitution strongly, we are not going to achieve very much. The rest, of course, the challenge is to see how it's put into action. Because as I said earlier, sometimes even under the 19th Amendment, maybe particularly under the 19th Amendment, and then thereafter too, even under the 21st Amendment, we saw severe challenges to the Constitutional Council, a tug of war between the executive and the Constitutional Council about certain appointments. So how it's going to be operationalized, we will have to work on that. And then, very briefly, one of the demands of the Aragalya was public participation in governance. And so this Jana Sabha was introduced as or suggested as an option. I think a new constitution will have to think about it. How are we going to increase public participation in governance? How should there be consultation, constant public consultation, in policy making? So one of the thoughts that keep, running through my head is, these sectoral oversight committees in Parliament can, be constitutionalized. And they should be strengthened so that, the public the public's participation is given constitutional recognition. Whatever the area may be, it may be economic development, it may be human rights, whatever the area may be, I think that there has to be some sort of an institutional arrangement to make the public participate in a very meaningful way, and that public representatives also take these consultations seriously. So this is about deliberative democracy, which I think the Aragalia really emphasized. So I'm not getting into electoral systems, public finance, public security, etc. I'm sure they might be addressed by the panel. Two very, I would say, one might say mischievous suggestions. One in particular, which is very difficult. I've spoken about these at various fora, and I must say the reception has been rather mixed. And sometimes there's a sense that this is about academics speaking about constitutional issues, you're not being politically realistic, etc. One is there's this trend, growing trend among new constitutions of including provisions in the constitution to guarantee intra-party democracy. I think that's very important. That's very, very important. The Kenyan constitution has these provisions. The Nepali constitution of 2015 have these provisions, which basically points to the fact that if you're running for national office, then political parties, the internal democracy of political parties is absolutely essential. They must be inclusive, and also they must be accountable to the public about the processes by which they govern the inner affairs of a party, how office bearers are elected. And for us, I think, as citizens, it's very important to know how candidates are nominated, on what basis. Because these are, parties, after all, run governments eventually. So if parties don't have intra-party democracy, how on earth are they going to govern a country in a democratic way? So I think this has to be a constitutional matter. So from the responses I see in the audience, well, there's sort of, I don't know, it's seen to be an interesting proposition, but I'm not quite sure, whether you think it's plausible in this context. The final point is the reception of international law into our legal system. That's absolutely of the essence, I think. Because we have this dualist legal system, and many of our agreements, whether they be in the field of trade, commerce, human rights, environmental protection, etc., cannot really be implemented unless they are transformed into domestic law. So that's a real stumbling block, and that Sri Lanka has taken a lot of flack for that. Of course, in the 1978 constitution, there's a special provision about agreements which are of an economic nature, but then not other types of treaties that Sri Lanka has ratified. So if we are going to be, surely a modern state that wants to play a key role in regional and international affairs, become a respected citizen, and particularly in a period when the rule-based system internationally is coming crashing down on us, for us to show our commitment to a rule-based system, I think we have to find a way of seamlessly integrating international law into our domestic legal system. So of course there's much to deliberate on. I'm sorry if I took more time than I intended to. There's nothing specific, as I said, but I just flagged some broad issues. So while these discussions take place, I think it's absolutely important to draw in the larger public. And perhaps now that there is discussion about education reforms, I think we should all make it a point to emphasize the need for civic education in the education system. We can't run a democracy only through constitutional reforms and legal reforms if indeed the young citizens of this country don't understand what it means to be a citizen, civic responsibilities, rights, the constitutional scheme of the country. extreme, at a very weak level at the moment, civic education. So I think all these come to mind when you think of constitutional reform, with some degree of cynicism, I think, but yet, we have to move forward with hope. Hope that there'll be a better tomorrow, that we will work on it with idealism and without this, this fervor to compromise, get into this horse trading, because the Constitution should be the, at the core of national life. So that it shouldn't be a compromised document. Even the 19th Amendment, at the end of the day, what the citizens got was a very compromised 19th Amendment. I mean, it had very good features, but it was very compromised. In order to get consensus in Parliament, many of the provisions were compromised. So I think that sort of cynical political approach should be rejected in favor of something which is in the national interest for this generations and also future generations to come. So thank you so much for your patient listening. Thank you.